Hello, everybody. Good evening. So, we're live here in my office at the Austin Financial Center. And tonight, okay, I want to share with you this great information, very important information I want to share with you about state planning. Organizations that we partner with is what we call the Inherit Guard, okay? So, I don't know if you've heard about this organization, Inherit Guard. Our campaign, World System Builder, as you can see, our national campaign for financial literacy partnered with this group of lawyers that help family with estate planning. So, did you know that less than half of Americans have any form of estate plan? Okay, even when families have completed estate planning documents, they often overlook mistakes or fail to properly fund or update their plan properly as time goes by. So, given how important proper estate planning can be for a family, it is critical to make sure you have the right documents in place to protect against unforeseen emergencies. Okay, here is some information that might be helpful as you plan to protect your estate and your loved ones. So, everyone has an estate to protect. Okay, without proper documents, upon death or incapacity, a court process may be necessary for your loved ones to receive the legal authority to act on your behalf or administer your estate. So the most common and necessary documents for your estate planning include the following. Okay, number one, the durable financial power of attorney. Okay, if you are alive but incapacitated and unable to manage your own affairs, okay, a durable financial power of attorney can empower someone you trust to manage assets and property, okay, including day-to-day needs for you. So without it, banks and other institutions are unlikely to allow anyone but the owner to access funds or make decisions until a court order names a conservator over your affairs. So that's why most of the time when people don't have a durable financial power of attorney, okay, no one can access your money, so your money stays there. Okay, so it's very important that you have this document. Okay, another one that you need to have is the living wills, okay, medical power of attorney, and healthcare directives. So what is this? Healthcare and medical decisions similarly require a written authorization for someone to make decisions on your behalf or receive protected personal healthcare information. Okay, the proper documents can nominate someone to manage your medical decisions if you are unable to for yourself. Make certain medical decisions in addition of needing life-sustaining care and or allow loved ones to receive medical information and have hospital visits without needing third-party permission. Insurance solutions can specifically address the need to pay for long-term care costs. When done properly, these documents can also avoid the need for a court-ordered guardian in the case of incapacity. Okay, very important, right? Durable financial power of attorney, living wills, medical power of attorney, and healthcare directives. Okay, what else? Did you know probate can cost a lot of money? Okay, take a long time. Family can cause family stress and give up your privacy. So imagine, if you have not prepared these documents, your last will and testament and revocable living trust, right? It's going to take a while for your family to access all the assets that you're going to be leaving behind. And then your assets are going to be frozen, okay? And then you're going to have to pay court fees and all of that stuff. Like a lot of stress in the family, right? And that's why it pays to prepare all these documents. So another one is last will and testament. Upon death, someone will need to be authorized to manage assets of your estate and distribute property to your heirs. Okay, if you have minor children, someone will need to be appointed as guardian. So all of you out there that have children below 18, okay, make sure you have a guardianship document. Okay, last will and testament allows you to designate who you want to fill those roles so that a probate court can appoint them. Okay, because without that, the government will assign, okay, your family to go to a foster home, and you wouldn't like that. Okay, next one. Revocable living trust. What is this? A revocable living trust can allow you to transfer assets at death without the need for court processes by leaving a trustee in charge of managing your estate in your absence. In order to do so, it needs to be properly structured and hold title or beneficial interest to all of your assets. It can also provide your estate with significantly more privacy than a probate process. Okay, because if your property is on probate, it is open to the public, so anybody can contest that. Okay, irrevocable trust planning. When more advanced planning for tax purposes, benefit qualification, or asset protection is needed, irrevocable trust can provide tremendous value. Irrevocable trusts can be complex and once established are not easily changed. That's why it's called irrevocable. You cannot change it, okay? Therefore, if you might have a need for irrevocable trust planning, it is important to consult with experienced legal counsel to discuss your options. Okay, also consider, will your loved ones be able to make necessary decisions for you in the case of emergencies? Is your estate set up to avoid the need for probate court proceedings? When was the last time you reviewed your estate planning documents? And are all of your assets owned by your trust, or are your beneficiary designations on accounts and assets up to date? Okay, so again, this company, Inherit Guard, okay, we offer free consultation, a 30-minute consultation. If you would like to know more, okay, send me a message here on Facebook and I'll be able to help. All right, so again, this is Elisa, your licensed financial professional and retirement specialist, also your registered social security analyst and also assistant principal. Happy Saturday, everybody. Have a blessed Saturday and have a blessed Sunday tomorrow.